Hi everyone, welcome to my channel and welcome to Manthan 2026. We have been able to cross 10,000 subscribers in less than a week of launch of this channel, and I'm truly grateful to all of you for the support that you have provided. And as I have been repeating every time, we would endeavor to provide you the best content out here on this particular channel, which would be relevant not only for the UPSC Civil Services examination, but if you are preparing for any other competitive examination, or if you are generally interested in knowing about the governance and political system in India, we would try to ensure that the content that is available here is not only relevant but is deeply enriching in nature. Today I am going to be talking about two really important issues that affect India as a democracy. पहले टॉपिक के बारे में हमने थोड़ी बहुत डिस्कशन भी करी थी अपने प्रीवियस सेशंस के अंदर, एंड दैट इज़ गोइंग टू बी प्रिजन रिफॉर्म्स, एंड द सेकंड टॉपिक इज़ गोइंग टू बी द एंटी डिफेक्शन लॉ. सो एज यूजुअल लेट मी बिगिन विद अ स्टोरी. द स्टोरी इज़ दैट ऑफ अ मैन नेम्ड मचांग लालुंग. ये जो आप इमेज देख रहे हैं मचांग लालुंग की ली गई when he was 77 years old, and the image that he is holding in his hand is when he was 23 years old. That is the first time when Machang Lalung was arrested by the police. The charge that was put up against him was of grievous hurt, not of terrorism, not of murder, not of rape, not of dacoity, but of grievous hurt. He was considered to be unfit for trial by the court at that point of time, और इसीलिए इनको तेजपुर मेंटल हॉस्पिटल के अंदर शिफ्ट किया गया. And then the sad story began. मचांग ललुंग की फाइल कहीं ना कहीं तेजपुर की डिस्ट्रिक्ट कोर्ट के अंदर खो गई, and for the longest time no one really bothered where Machang Lalung was. It was only when he was 77 years old in 2005 that the National Human Rights Commission and one lawyer whose name was Radhakant Tripathi discovered him during a routine inspection. He walked out of the hospital at the age of 77 finally. 54 years is what he spent where he was not even given a trial by the legal system of the country. That is the unfortunate situation in which we stand today. Machang Lalung is not just the problem, but Machang Lalung is a symptom of a larger problem that plagues the judicial system of the country. Why is it that people in India tend to undergo trial for the longest period of time? Why is it that almost 2/3 of prisoners in India are under trial prisoners? People, those who have not been convicted. Individuals, those who are simply undergoing a trial and are accused of offences. Today I am going to be talking about one of the most invisible institutions in India's governance system, and that is the prison system in India. We'll try to understand India's constitution that promises Article 21, that promises right to life and personal liberty, that promises a fair procedure for every individual in the country according to the law. Why has it failed to be able to provide justice to people like Machang Lalung and many others? So let's begin. Before I get into the understanding of how the prisons work in India, let me quickly take you through some of the numbers as far as the Indian prison system is concerned. नेशनल क्रिमिनल रिकॉर्ड्स ब्यूरो हर 1-2 साल के अंदर अपनी रिपोर्ट्स पब्लिश करता है with respect to the prison statistics in India. And some of the statistics that we are going to be discussing about today are going to be extremely shocking and saddening for many of you. First, if I was to talk about the statistics related to prisons in India, the first and the most important statistic that we need to know is that there are round about 1300 prisons in India. और इन prisons की जो capacity है that stands at somewhere around 4.5 lakh people. But the number of people those who are held in these prisons of India as of today is 5 lakhs. That means there is an over occupancy of almost 120% in India's prisons. तो जहां पे 100 लोग इंडिया के प्रिजन्स में होने चाहिए वहां पे आज हम 120 लोगों की बातें कर रहे हैं. And this number is really jarring for some of the specific states in India. For example, if I was to talk about Uttar Pradesh, Meghalaya, Chhattisgarh, this number stands at somewhere around 175%. And for the national capital of Delhi, this number stands at approximately 200%. अगर एक जगह के अंदर जहां पे एक आदमी आना है वहां पे 2 लोग होंगे, 100 लोग आने हैं वहां पे 200 लोग होंगे, एक सेल जहां पे 6 लोग आने हैं वहां पे 12 लोग होंगे, तो you can imagine what the situation is going to be. It is going to result in poor sanitary conditions. The hygiene in some of these prisons are going to be extremely poor. There is also a possibility that people may not even be able to get sleep. So poor rest for people, those who are going to be a part of these prisons. There is also a possibility जब आप इतने सारे लोगों को इस तरीके के environment में stuff कर देंगे, many of them may end up quarreling and fighting with each other, and it may result in a lot of violence within the jail premises as well, and that is something that I will discuss very shortly. So violence and riots become a regular occurrence in India's prisons. And not only that, but सांस लेने की भी जगह नहीं रहती है. So the most basic conditions that a person needs in order to be able to live with dignity would also be impacted significantly as a result of such overcrowding of prisons in India. And this is not the only shocking statistic that we need to be knowing about and the impact of these shocking statistics. The other shocking statistic is that almost 70% of the prisoners in India are under trial prisoners. These people are not convicts. What that means is they have been accused of offenses and they are undergoing a trial. Until the time their trial goes on, they are going to be behind the bars. So another shocking statistic therefore to keep in mind is that in India, under trial prisoners form almost 70 to 75% of India's prisons. Almost 70 to 75% of India's prisons. दिल्ली के अंदर, बिहार के अंदर, this under trial prisoner population is almost 87% of the prison population. So we can also mention about states like Delhi and Bihar having these numbers standing at almost 87%. Shocking statistics. But you know what is even more shocking? Nearly 50% of these under trials are between the age of 18 to 30, and almost 70% of these under trials belong to scheduled caste, scheduled tribe, OBC and minority communities. Almost 50% of under trials are between the age of 18 to 30 years, wasting some of the most important years of their youth in prisons of India. And as I said, not just this, but almost 70% of the undertrials are belonging to marginalized communities in India. इसमें कुछ शॉकिंग स्टैटिस्टिक्स और भी हैं. Women prisoners are almost 1318 in total in India, with almost 1492 children. और ये वो बच्चे हैं जिनका कोई खुद गुनाह नहीं है, but their only crime is that their mothers are in prison. So I am talking of almost 1300 women prisoners in India, and along with these 1300 women prisoners in India, we are talking of almost 1400 children who are also accompanied along with their mothers, and as I said, that their only crime remains to be that their mothers are behind the bars. And the last and a very deepening, shocking, saddening statistic is that almost 2000 people die in the Indian prisons or in the Indian police custody every year, and several of them are suicides because of the mental stress, trauma that is caused to the prisoners in India. So when I am talking about what are the effects of overcrowding of prisons, when I am talking about what are the effects of large number of undertrials prisoners being there in the prisons, we can also mention that it has a significant impact on the mental health of the prisoners as well in India, which is in an extremely poor state. These are some of the statistics that we need to be aware of, and things that can be quoted by some of you, those who are writing the mains examination this year, in your answers. Now, let's go back into history and talk about how the prisons were managed in India, or what are some of the aspects that we need to know about the history of prisons in India. What is the colonial legacy of the prisons in India? The entire story starts from 1835. In 1835, Macaulay chairs a committee on prison discipline. As you can read, the objective of this committee was to ensure discipline in the prisons in India. इसकी philosophy बहुत straightforward थी. The prisons are not places to reform. Prisons are places to punish those who have committed crimes against the society or those who have violated the law. Prisons were places to deter people from committing more crimes. Prisons were places to break the will of individuals. Prisons were places for hard labor. Prisons were places for monotony. Prisons were places for torture of individuals. The emphasis, therefore, of this prison discipline committee was not reformatory in nature. It was to punish individuals. That's the kind of mindset which shaped the colonial powers to set up the prisons in India. In 1894, a seminal law was passed by the British, and that was called as the Prisons Act of 1894. And what is the most unfortunate thing is that despite becoming an independent republic in 1950, we continued to pursue this law in India. and this law continues to be in force in India even till date, in some form or the other in most of the states in the country. For that matter, in 1919, the British had set up another committee, and this committee was called as the Indian Jails Committee, which was headed by Sir Alexander Cardew. For those of you who are writing the mains examination, you need not remember each one of these facts. But if you are able to just build a broad story in your mind, and if you can quote some of these things wherever you feel in your answers, it will definitely give you an edge over the other candidates, those who are writing the examination. पर मेरा ये बिल्कुल भी कहना नहीं होगा कि आप ये सारी committees के नाम याद रखें या आप ये years के नाम याद रखें, but हाँ कुछ important चीज़ें ज़रूर हैं. For example, the 1894 Prisons Act is still the most important law that governs the way the prisons are run in India, और वो हमें ज़रूर याद रहना चाहिए. But other than that, you don't need to necessarily focus on knowing each and everything that I am telling you here. But the point that I am trying to basically make here was that the Prisons Committee, the Indian Jails Committee, had also provided certain recommendations as to how the jails in India or the prisons in India need to be made better, but unfortunately most of these recommendations were not really implemented in an effective manner. And as I said, on 26th of January 1950, when India became a republic and we adopted Article 21 in our constitution, we gave a promise to the citizens of India that their life and personal liberty would not be deprived unless there is a procedure that has been established by law, which has been followed by the state. And that procedure would be a fair procedure. But unfortunately, we have not been able to keep up the promise of Article 21 of the Indian Constitution. A very important other concept that you also need to know is that prisons as a subject are mentioned in entry 4 of list 2 of the Indian Constitution, which is nothing but state list, which means that prisons as a subject in India are supposed to be governed by the laws made by the state legislature. And the only thing which the union can do at max is to make a model law and request the state governments to adopt these laws. And that has been one of the biggest reasons because of which the way the prisons are governed in India is extremely non-uniform in nature across the country. In some parts of India, prisons have been able to do reasonably well. For example, we are going to be discussing about Rajasthan and the concept of open prisons in Rajasthan, and they have been able to do reasonably well as compared to the other states in India. Andhra Pradesh has also done reasonably well, Maharashtra has done reasonably well, but there are various states that lag behind significantly. I already gave you the numbers associated with Bihar and Delhi, which we need to keep in mind. So as long as this subject is going to remain in state list, the onus of prison reforms in India ultimately is going to fall on the shoulders of the states. And until and unless there is some kind of synchronization or agreement between the states as to what kind of reforms are supposed to be brought in, we are staring at a very bleak future in India as far as the prison reforms are concerned. Now, 26th of January 1950, when the Indian Constitution came into force, the Indian Constitution makers included several provisions in the Indian Constitution in order to ensure that the fate which the prisons faced in India during the colonial times is not going to be the same after independence. So let me quickly talk about what are some of the important provisions in the Indian Constitution as far as the prisons and the entire gamut of provisions related to prisons is concerned. The first and the most important article of the Indian Constitution that we need to know related to the prison governance in India is Article 21 of the Constitution. Article 21 of the Indian Constitution, as we all know, says that no person shall be deprived of life and personal liberty except according to procedure established by law in India. And in 1978, in the Maneka Gandhi case, the Supreme Court of India had also stated that when a person is deprived of their life and personal liberty, the procedure that must be followed for depriving them of their life and personal liberty must be a fair, reasonable and a just procedure. So, the procedure to deprive a person of life and personal liberty must be a fair, just and a reasonable procedure. A fair, just and a reasonable procedure. कोई भी प्रोसीजर नहीं, एक फेयर, जस्ट और रीजनेबल प्रोसीजर. इसका मतलब है कि जो ट्रायल भी एक इंडिविजुअल को इंडिया के लीगल सिस्टम के अंदर मिले वो एक फेयर ट्रायल हो. जिस तरीके का ट्रीटमेंट एक इंडिविजुअल को जेल में दिया जाए वो भी एक फेयर ट्रीटमेंट हो. बिकॉज अगर आप किसी की पर्सनल लिबर्टी या लाइफ को छीनते हैं वो केवल एक फेयर प्रोसीजर के थ्रू होना चाहिए. और इसका मतलब ये है जो पूरी जेल और प्रिजन की कंडीशंस हैं दे शुड बी ह्यूमेन. They should ensure the protection of human dignity. Not just that, but we should also know about the provisions of Article 22 of the Indian Constitution, which provides protections against arbitrary arrests and detentions. Against arbitrary arrests and detentions. Thirdly, we can also quote Article 39A in the Indian Constitution, which is a directive principle of state policy, which is giving a responsibility to the state in India to provide free legal aid and to ensure that justice is not denied to people simply because they do not have enough resources. But unfortunately, most of these provisions of the Indian Constitution have remained only on paper when it comes to prisons and conditions in prisons in India. A large number of people in India continue to remain under trial prisoners simply because they are not able to afford legal aid for themselves. They do not have someone who can get them bail, who can get them out of the prison. They do not have someone who can tell them about what their rights are under the Indian Constitution. So Article 39A, that is imposing a responsibility on the state to provide free legal aid and to ensure that justice is not denied to any individual because of their economic situation. A very important judgment that was given by the Supreme Court of India in 1978 was Sunil Batra versus Delhi administration. And in this particular case, Justice V. Krishna Iyer, one of the stalwarts of India's Supreme Court, one of the most respected judges of the India Supreme Court, stated that prisoners in India continue to retain their fundamental right even in the prisons except those rights which are necessarily lost as a result of them being put behind the prison. What that essentially means is that, of course, a person who is in prison would not have the right to movement or right to reside anywhere throughout the territory of India, but the other basic fundamental rights of a prisoner, such as right to freedom of speech and expression, or right to practice their religion, or right to be able to think, or right to be able to form an association, organization, is something that would continue behind the four walls of the prisons as well in India. Around the same year, there was a judgment that was given by the Supreme Court in a case related to Charles Shobraj as well, and where the court said that as far as life of a person inside the prison is concerned, Article 21 would continue to apply to them behind the prison walls as well. So apart from the Sunil Batra versus Delhi administration case where Justice V. Krishna Iyer and Charles Shobraj had made such an important observation, we should also know about an important judgment of the court in Husainara Khatun versus State of Bihar. Many of you, those who have studied polity from me in foundation batches, would know that I tend to emphasize a lot on this particular case. This is a judgment that was provided by the Honorable Supreme Court in 1979, and the Supreme Court in this particular case said that Article 21 of the Indian Constitution includes even the right to speedy trial and justice in India. And if any citizen of India is being denied speedy trial and justice, it is a violation of their right under Article 21 of the Indian Constitution. In this particular case, Justice P.N. Bhagwati came to know that there are large number of under trial prisoners in Bihar, those who have spent way more time as compared to what they would have spent when they had been convicted of the offences. ऐसे बहुत सारे केसेस थे जहां पे जिन लोगों को 5 या 6 साल की सजा काटनी थी, वो एज एन अंडर ट्रायल प्रिजनर जेल के अंदर ऑलरेडी उस समय से ज्यादा समय बिता चुके थे. सो जस्टिस P.N. Bhagwati, with one stroke of his pen, ensured the release of more than 40,000 prisoners from the prisons of Bihar as a result of judgment provided in this case. Justice P.N. Bhagwati in this case was therefore the one who was acting as the champion of the rights of the prisoners in India by stating that Article 21 includes right to speedy trial and justice in India. Because if the trial that is provided in the courts in India is not fast enough, there would be a situation which would arise in the country where people would lose their faith in rule of law in the country. And we have already discussed what happens when people end up losing their faith in rule of law. People end up taking law into their own hands. The Bhagalpur blindings that we know happened in Bihar was a result of the same. जहाँ पे पुलिस वालों को लगा that the situation of so many criminals in the state of Bihar is that if we even catch them and put our lives at risk, they are always going to get away because they would have some or the other political connections. So it is better that we take law into our own hands to teach lesson to these criminals, and they poured sulfuric acid into the eyes of these prisoners, those who had been caught by the police. And that is what they called as Ganga Jal, and what has been depicted in the movie Ganga Jal as well as unfortunate case of the Bhagalpur blindings in India. So these are some of the constitutional provisions as well as the history of the entire prison in India, or the subject of prisons in India. Now let me take you further deep into the subject and talk about what are some of the challenges that exist as far as the prisons in India are concerned. What are some of the difficulties that we have been facing with respect to the prisons in India? What have been some of the fault lines? What have been some of the failures with respect to the prison administration in the country? We were talking at the beginning about Machang Lalung. But Machang Lalung is not the only person who has been languishing in jails in India or who has been undergoing trials for the longest period of time. In 2011, a case came up in front of the Supreme Court of India, and this case was known as the Bhim Singh case. This case was of a man from Bihar who had spent 24 years as an under trial in the prisons of Bihar for an offence which carried a maximum sentence of 7 years. तो प्रॉब्लम कहीं ना कहीं सिस्टमिक है, एंड देयरफॉर इट इज वेरी इंपॉर्टेंट फॉर अस टू अंडरस्टैंड व्हाट आर दी स्ट्रक्चरल, व्हाट आर दी सिस्टमिक challenges that exist with respect to India's legal system that make India's prisons a hell. First and foremost, when we talk about challenges and difficulties that lead to such a situation with respect to the prison administration in India, first issue is that of over arrest in the country. The police tends to make over arrests in India a lot of times, and that's one of the reasons because of which we end up having so many large number of people in the prisons in India. Section 41 of the old Criminal Procedure Code and now Section 35 of the Bharatiya Nyay Suraksha Sanhita requires the police to arrest people only when it is necessary. Even in a very important judgment of the Supreme Court in Arnesh Kumar versus the state of Bihar, Supreme Court of India had laid down detailed guidelines with respect to the way the arrests are supposed to be conducted in India. And the court had also stated that the police must clearly state on record what are the reasons for the arrest of an individual. But unfortunately, these directions provided by the Supreme Court in the Arnesh Kumar case, or for that matter, the directions under Section 35 of the BNSS, are routinely ignored by the police. One of the major reasons for that possibly is the lack of capacity building and training amongst the police officers in India. The second and a big reason for such large problem of the under trials in India could also be attributed to bail denial in India. The Supreme Court of India, in a very important case known as Satyendra Kumar Antil, had stated that bail is the rule and jail an exception. अगर एक आदमी के ऊपर ट्रायल चल रहा है और कोर्ट को यह विश्वास है that this person will keep coming back to the court whenever hearings will take place, this person would not run away, this person would not tamper with the evidence or witnesses, this person would not commit any other crime while he's out there in the society, why should that person be kept behind the bars? Don't we believe in the principle of innocent until proven guilty? And if that is the principle that we believe in, why to keep that person behind the bar while his trial goes on for the longest time, simply because the Indian courts and the legal system moves in a very slow manner? Should this person not be out on bail in the society? That's the question that we need to ask ourselves. But unfortunately in India, even despite this judgment of the court, the lower courts in India do not tend to follow the principle of bail is the rule and jail is an exception. And one of the reasons which I have identified through my own experiences and learnings has been that the judges in the subordinate courts in India are often not willing to take the risk of providing bail to the accused. The reason for that is because in the past, when many such judges have gone ahead and provided bails, they have been reprimanded by the high courts. So lack of independence of the district judiciary in India and the pressure that they get from the high courts to not provide bails, which often results in punishments, which often results in the demotions, which often results in reduction of salaries and allowances for the judges, has been one of the biggest reasons because of which we have seen that the bail is often denied to the people, those who are undergoing trial in India. The third reason that we can also mention is the failure to provide adequate and timely legal aid to individuals. If a person is not going to be aware of what their rights are, in the legal system, if a person is not going to be aware of how they can actually get out of the jail on a bail, then what do we expect? In such a situation, of course, the number of people, those who are going to be under trial prisoners in India, is only going to pile up. There is another problem that we need to know. In the present provisions of BNSS, there is section 479. This has replaced section 436A of the CRPC. What this provision basically says is that if there is a person who is an under trial and he has already undergone half of the punishment of what he would get if in case he was convicted for an offense, then he should be let out of the prison. तो अगर किसी आदमी को अपने एक ऑफेंस के लिए जिसमें वो अक्यूज्ड है मैक्सिमम सजा 8 साल मिल सकती है और वो आदमी अगर ऑलरेडी 4 साल जेल के अंदर एज एन अंडर ट्रायल बिता चुका है, then that person should be released on bail. But unfortunately, this particular provision of the BNSS has remained as a dead letter in India. In most of the cases, the prison authorities have failed to take action in such cases where an individual was actually legally liable to get bail according to the law of the country. So these are few reasons that we need to know as far as the legalities of why in India we have such poor condition of prisons and why we have such large number of under trials in the country. The second problem that we need to know is about what it does is these overcrowding of prisons in India leads to extremely poor living conditions in the prisons in India. Let me tell you about some of the aspects of what it leads to. First and foremost, if the prisons in India are going to be packed at 200%, we can expect that the spread of communicable diseases in the prisons in India is going to be at a much faster pace than what it may happen in the natural society out there. Not only that, but overcrowding of prisons, as I told you earlier, leads to riots as well. In 2012, for example, there were riots in Nagpur jail. Similarly, in 2013, riots broke out in Alwar jail and so on and so forth. So we can be even quoting about these riots as well that have been happening in the jails in India in our answers as a result of the overcrowding of the prisons in the country. Not just that, but Justice Amitav Roy Committee, which had given its report to the Government of India on prisons reforms in 2018, had stated that there is a shortage of at least 30 to 40% as far as the prison staff in India is concerned. देखिए किस तरह की हालत हमारे जेल्स के अंदर है. And another big problem that is associated with the overcrowding of the prisons and the problems within the prison administration in India is significant number of cases of custodial deaths and torture. One of the most famous cases that has come up in the recent times is that of Father Stan Swami. Father Stan Swami was 80 years old. He was suffering from Parkinson's disease, but he was denied even a straw and a sipper to drink for few weeks. He finally died in judicial custody, in 2021 of July without ever being given bail by the Indian judicial system, without even ever going to trial in India. The National Human Rights Commission in its report has stated that there are significant number of custodial deaths that take place in India every year. Between 2020 and 2022, over 5,000 people died in judicial and police custody in India according to the statistics that have been provided by the NHRC. The other big challenge which we also should know as far as the judicial, as far as the custodial violence in India is concerned is that India has still not ratified the United Nations Convention Against Torture, despite the fact that we have become a signatory to this particular convention in the year 1997 only. Even the Law Commission in India has given several recommendations, including making an anti-torture legislation in the country, but it is something that is still awaited in the country. And a few other things that we also need to know with respect to the problems of the prisons in India is how the segregation of the labor that is supposed to be done by the prisoners or the prison inmates in the prisons in India is done according to the caste. For that matter, in 2024, the Supreme Court had given a landmark judgment, and this case was named as Sukanya Shanta versus Union of India. In this particular case, the Supreme Court had declared several provisions of the state prison manuals in India that assigned work to the prison inmates on the basis of their caste. For example, it mentioned some of the tasks in the prison as menial work that was to be given only to people from the so-called lower castes. Not only that, but cooking and some other activities were to be given only for the people of the upper caste in the jails in India. This is truly unfortunate. Think about the significance of this particular judgment. It took the Supreme Court of India in 2024 to tell the Indian prisons that caste discrimination is unconstitutional. It goes against the very grain of our constitution under Article 14, 15 and 17. Not just that, but it also promotes the entire practice of untouchability, which is very prevalent in the Indian society. The last and a very significant problem that I want to talk about with respect to the prisons in India is that a lot of data related to the prisons in India is not available publicly, or the data is not published in a transparent manner by the government authorities in India. A very simple example that I can give is that often the report that is published with respect to the prison statistics in India is published 2 years late, and it is often also carrying a lot of misleading facts as well as per various experts. So these are some of the challenges that are associated with the functioning of the prisons in India that we need to be aware of. और ऐसा नहीं है कि इन प्रॉब्लम्स को सॉल्व करने के लिए इंडिया के अंदर कमिटीज नहीं सेटअप की गई हैं. ऑफन थिंग्स मूव इन इंडियन गवर्नेंस सिस्टम ओनली व्हेन अ पर्टिकुलर कमिटी recommends what are the changes that are supposed to be made, the way the things are supposed to be reformed in India. So what are some of the important recommendations that have been made by some committees with respect to prison reforms in India? Let's discuss those recommendations as well. They would be particularly useful for all of you those who are writing the mains examination this year. First and foremost, you should know about a very important committee that was set up by the government of India and gave its report in 1980, and this was called as Justice A.N. Mullah Committee. Justice A.N. Mullah Committee had recommended, amongst many other things, that there should be a national prison policy that should be made in India, which will help all the stakeholders in following a common approach with respect to the functioning or the working of the prisons in the country. Secondly, it had also recommended that India should try to adopt a uniform legislation to govern the prisons in India instead of the different laws that exist across different states in India. It also recommended that on the lines of the All India services such as the IAS, IPS or the forest services, there should be an All India prison services cadre that should be established in India, which would be purely focused on maintenance and the functioning of the prison system in the country. Fourthly, it had also recommended setting up of a National Prison Commission, a body that would be responsible for providing recommendations from time to time and observing the functioning of the prisons in the country to ensure their effective functioning. Another commission which was set up by the government few years later was led by Justice V. Krishna Iyer, and this was set up in 1987. Unfortunately, most of the recommendations of the Justice A.N. Mullah Committee were not really recommended effectively. Justice V. Krishna Iyer Committee focused specifically on the women prisoners in the country. It recommended that for the women prisoners, there should be separate institutions, there should be more recruitment of women staff, and special healthcare services should be provided to the women prisoners. So the emphasis was on women prisoners and on having separate institutions for the women prisoners. This committee, as I suggested, also recommended that there should be special healthcare services also that should be provided to women prisoners, along with certain child care provisions also to be installed in such prisons. The second ARC in its 5th report on public order and 10th report on personal administration had also talked about capacity building of the prison staff in India, so that they are provided adequate training, not just in procedures but in sensitivity as well, to deal with the prisoners in a better manner. One of the important points that you should keep in mind while answering in mains is that prisons are not necessarily a place for punishing people. Prisons are not necessarily a place for retribution, but prisons are a place where individuals can be reformed, individuals can be rehabilitated. Unfortunately, in India, most of the time when we talk about prison reforms, we are only talking from a retributive perspective. But prisons need to be made a place where individuals can look for a better life for themselves going ahead in the future. And the last that we can also talk about is the Justice Amitav Roy Committee. Justice Amitav Roy Committee had provided its report in the year 2018 to the Government of India with respect to prison reforms, and it had also made several important recommendations, including setting up an all India prison services cadre. It had recommended with respect to introducing the provisions of bail and training the judicial staff in being and giving them more encouragement to go ahead and to provide the bail to individuals, so that the under trial prisoners in India can be reduced in a significant manner. एंड उसके बाद भी बहुत सारी और रिपोर्ट्स आती रही हैं. लॉ कमीशन हैज प्रोड्यूस मल्टीपल रेलेवेंट रिपोर्ट्स. फॉर एग्जांपल द 70th report of the law commission was on the congestion of the 270th report of the law commission was on the decongestion of the undertrials in India. The 268th report of the law commission was also focused on the bail reforms in the country. Now let me also tell you that there was a recommendation which had been made by Justice Amitav Roy committee and by several other committees as well, that the union must make what is called as a model prison law, which can act as a model for the states to adopt in India and which can help in ensuring uniform legislation throughout the country with respect to the prisons in the country. So let's talk about some of the important aspects of the Model Prisons Act of 2023 and what are the suggestions or what are the ideas that have been highlighted in the Model Prisons Act of 2023. First and foremost, what are some of the important suggestions made by the Model Prisons Act of 2023? The Model Prisons Act of 2023 changes the language of the act itself. It does not want to call people, those who are in prisons, as prisoners, rather wants to call them as inmates. It moves from calling the prisons to correctional services or correctional facilities. So the name prison itself carries a very negative connotation and it needs to change its name to correctional facilities. The second and a very important thing which has been recommended by the Model Prisons Act of 2023, which I am going to be discussing very shortly, is setting up of open or semi-open prisons in India. Open or semi-open prisons in India. It also talks about the judicial system, the legal system being more inclined to provide furlough, being more inclined to provide parole and premature release with certain criteria of individuals, those who are in the prisons. Of course, ultimately whether the provisions of the Model Prisons Act of 2023 would be adopted by the states would depend upon how serious the states are, what is the kind of political will that is shown by the state leadership in India towards this particular issue. The other interesting idea which has been highlighted by the Model Prisons Act of 2023 is relying on technology. Technology has been something which has been used extensively in some of the Western countries, some of the developed countries of the world, where there an e-tracker is placed either on the leg or on the hands of the prisoner, and then they are let to go out, and the court is then able to track in where the individual is, and there is some kind of a geo-fencing also that is done around that individual. The Model Prisons Act of 2023 has also recommended video conferencing to be introduced for the trials to be conducted in India. And the last and a very important thing which has been highlighted by the Model Prisons Act of 2023 is on regular staff training of the prisons. So that they are more aware of what the rights of the prisoners are, they are more aware of the sensitivity that they need to show as far as the prisoners are concerned, and the kind of the manner in which they need to conduct themselves while they are performing their duties. Now, one very interesting experiment which I was telling you, which needs to be possibly adopted and which has been recommended by the Model Prisons Act of 2023, is the idea of having open prisons. So what exactly is an open prison? In 1963, Sanganer in Rajasthan set up an open prison which as of now has more than 500 inmates. An open prison is a prison where there is minimal security, there are no bars, there are no chains that have been put on the prisoners. Rather, there is a certain amount of trust that is shown on the prisoners. Every day there is a first roll call that takes place on which every prisoner has to show their attendance. After that first roll call, the people are allowed to move out of the prison, and then they need to be back in the prison when the second roll call takes place. During this time, they can go and conduct their regular activities, they could be involved in some kind of employment, and not only that, but they can also be living with their families in the prison complex. Their children can go to local schools, their wife can run the households, and they can lead just a normal life like any other individual without feeling that they have been put behind the bars. Of course, there is some kind of criteria that is supposed to be followed with respect to the open prisons, and which is that the person who must have been only convicted can undergo to a open prison, and secondly, एक वो इंसान जिसने कम से कम 5 साल की सजा काटी हो और जिसका बिहेवियर प्रिजन के अंदर अच्छा रहा हो. ऑफ कोर्स दीज क्राइटेरिया कैन वेरी फ्रॉम वन स्टेट टू अनदर, एंड there are studies that have been performed by various experts. For example, there was a study that was performed by Smita Chakrabarti of the Rajasthan State Legal Services Authority, and they said that the escape rate from the Sanganer prison is almost negligible. जो आदमी इस प्रिजन के अंदर रहता है वो यहाँ भागने की कोशिश नहीं करता है. In fact, there have been various cases where people, those who have spent time in this prison, have been rehabilitated and they have become an integral part of the mainstream society as well. This is an experiment which has been recommended by various expert committees and bodies over a long period of time, but unfortunately in India, there are only few states which have shown the political will to set up the open prisons in the country. Now, having talked about all of these issues related to the functioning of the prisons in India and the constitutional provisions and their history, it's important for us to also know what the way forward should be as far as the prisons in India is concerned. अगर हमें truly India के अंदर prisons को ऐसा बनाना है which reflects the 21st century and which reflects the kind of society that we take pride in, then what are the things that we can be recommending there is what we should also be discussing. इसमें दो तीन चीज़ों के बारे में जो हम बात कर सकते हैं. First and foremost, we need to replace the Prisons Act of 1894 with a model law, the 2023 law which has been proposed. The second thing is that we need to significantly decongest the prisons in India. One of the ways in which this can be done is aggressive implementation of section 479 of the BNSS by releasing the under trial prisoners, those who have spent more than 50% of their time in the prisons in India where they would have been convicted of a particular offense. The other thing which needs to be done is to reform the bail law in India. It is very important that जो गाइडलाइंस कोर्ट ने सतेंद्र अंतिल केस के अंदर दी थी उनको कोडिफाई किया जाए और उनको एक लेजिस्लेशन के फॉर्म में लाया जाए. Not only that, but we need to ensure greater independence of the district judiciary in the country as well, so that they can act in a free manner and they can go ahead and provide bail to the individuals, those who are accused in different offenses, and they should not fear repercussion from the high courts in India. A very important thing that is supposed to also be done is that we need to invest aggressively in staff and infrastructure of the prisons in the country. We need to fill vacant positions as was highlighted by various committees of the government of India. We need to have psychologists, we need to have professional counselors as well as individuals, those who are trainers, those who can give motivation to the prisoners to start a new life once they are out of the prison. And last and most importantly, we need to have effective audit mechanisms as well for the prisons in India. There are provisions in Indian law with respect to a board of visitors, those who should be visiting the prisons in India on a regular basis, but unfortunately these provisions remain only on paper. Let me therefore go back to the story of Machang Lalung. Machang Lalung was released in the year 2005. By the time he returned to his village, everything has changed around him in his life. He had entered into a village which was completely unknown to him. His friends were no longer there. His family members had either passed away or had completely forgotten him. The story of Machang Lalung is not the story of Machang Lalung alone. It is the story of everyday prison in India. It is the story of a woman in Bihar whose child is being raised inside a prison. It is the story of a man in Delhi who has spent more than 15 years behind the bars even though he is merely an accused. It is the story of a tribal from Chhattisgarh who has been charged under the UAPA law and who has never met a lawyer ever in their life. In the words of Justice V. Krishna Iyer, where he stated that the worth of a country, the stature of a nation is not decided by how it treats its most powerful citizen, but how it treats its most weakest ones. Machang Lalung was the weak citizen of India. Machang Lalung, at the age of 77, was released from the prison. He lost 54 precious years of his life and had seen the worst of the Indian prison system and the Indian legal system. It is therefore required that the political class in India shows extreme political will. There is pressure that is built from the citizens, and the prison authorities and the judicial authorities in India pull up their socks in order to truly reform the prisons into what would be befitting of a 21st century nation. So this is all about the prison reforms that I wanted to discuss with you in today's session. Now let's move on to another very interesting topic, but before that let me also tell you what could be the probable questions that you can expect from this topic in the mains examination. One very interesting question that I have framed here, which you can try to attempt, is bail is the rule and jail is the exception, yet nearly 3 out of every 4 prisoners in India is an under trial prisoner. In the light of this statement, critically examine what are the causes of large number of under trial prisoners in India. Is it legal? Is it administrative? Has it to do with something with the judicial system, or is it something to do with the policing in India? And suggest measures drawing upon some of the recent judicial and legislative developments that have taken place in India. You may mention about the Model Prisons Act of 2023, and you may also mention about some of the important judgments that have been given by the court with respect to this particular topic in the recent past. Now, let's move on to the next topic, and this is again a very interesting topic from the perspective of Indian polity and governance. Again, let me take you back in time. The year is 1967. Haryana as a state was barely a year old. It was carved out of Punjab in 1966 और हरियाणा के अंदर पहले चुनाव हुए, पहले first assembly elections were held, 81 seats. Congress party was able to get into power with 48 MLAs. But within a few months, 12 MLAs of the Congress party defected. They formed a new political party and the Congress government had fallen. Amongst all of these people, there was one individual who stood out, and this individual's name was Gaya Lal. Gaya Lal had won from Hasanpur constituency of Palwar district in Haryana as an independent candidate. Actually, Gaya Lal wanted to contest on a Congress ticket, but he was not provided Congress ticket, so he became rebellious and he went and contested the elections as an individual or as an independent in the 1967 elections. But what happened afterwards is what is really interesting. As he won as an independent candidate, over a single day in March 1967, Gaya Lal did something that would put his name into the annals of history in Indian politics forever. The first thing which Gaya Lal did was that within a few hours, he went and joined the Congress party. But a few hours later, he left the Congress party and joined the United Front. And then by evening, he was back with Congress again. So Gaya Lal was able to change 3 political parties in one day. 9 घंटे के within, according to many accounts, Gaya Lal had changed 3 political parties. इतने तो कपड़े भी लोग एक दिन के अंदर नहीं बदलते हैं जितने गया लाल जी ने एक दिन के अंदर political parties बदल ली. उसी शाम वन कांग्रेस लीडर राव बीरेंद्र सिंह ने एक प्रेस कॉन्फ्रेंस बुलाई और उसमें साथ में गया लाल जी को भी बुलाया और उन्होंने एक बहुत ही फेमस डायलॉग बोला और उन्होंने पूरी प्रेस कॉन्फ्रेंस के सामने ये बोला दैट गया राम जी अब आया राम जी हो गए हैं. And that went on to become one of the most commonly acceptable and known phrase in Indian politics, known as the Aaya Ram and the Gaya Ram politics. The Home Minister at particular point of time, YB Chavan, used a version of it on the floor of the Parliament in India, and he said that India has officially entered into the era of Aaya Ram and Gaya Ram politics. So today we are going to be talking about the various aspects related to the Aaya Ram and Gaya Ram politics in India. What are the laws that have been made in India in order to prohibit this Aaya Ram and Gaya Ram politics? There is an anti-defection law which was enacted by the Parliament of India in 1985. That's what we are going to be discussing. What are some of the important provisions of this law? What are some of the issues that have emerged with respect to the enforcement of this particular law? So before I begin, let me quickly talk about what do I understand by defection and why does it even matter in the first place. So let's begin. There is some technical glitch that I need to be addressing here. Anyway, yes, I've been able to open the note here. This is a new device for me, so I am still trying to grapple with how I am supposed to be working on this. Also, by the way, before I go further, I want to tell one more interesting thing, that as of now, I am just a single man team who is trying to run this channel on my own by myself. And therefore, there are often a number of technical glitches that I face. As you would know, I am a millennial, I am not a Gen Z like many of you. And therefore, what tends to happen is that कई बार मैं बहुत सारी चीज़ें करने जाता हूँ और वो उल्टी हो जाती हैं, और उसी रीज़न की वजह से कई बार मेरे कुछ एपिसोड्स डिले हो जाते हैं अपलोड होने में. So I would really want to apologize to all of you, those who have been trying to set the schedule around my Manthan series, but I will try to fix these issues. अभी मेरे को हार्डली 10 दिन हुए हैं यूट्यूब चैनल लॉन्च किए हुए. आई एम स्टिल लर्निंग एंड बट आई प्रॉमिस दैट आई विल बिकम बेटर एट दिस. And if any one of you who is willing to help me with running this YouTube channel, of course at this point of time I am not earning anything out of it and I am giving a lot of time to this activity, I would not necessarily be able to pay you anything at this time. But अगर आप में से कोई मुझे help करना चाहे, someone who has expertise and interest in running this, I would be more than happy to hear from you. You can always mail me. Anyway, now let me talk about firstly what do I understand by defection. Because we are wanting to talk about the anti-defection law in India, तो defection का मतलब क्या होता है? There was a book that was written by Dr. Subhash Kashyap, who is a foremost constitutional expert, who had defined defection as abandonment of loyalty or duty or principle. So if you were associated with some principle or you believed in loyalty to a particular political party or to a particular person or to particular political ideology, and when you abandon that for a particular cause, we call that as defection. Defection can also be stated as when a person changes his allegiance. So simply stating, I could say when there is a change that takes place in allegiance, it can be called as defection. Now, let's quickly talk about why defection is so important. सबसे इम्पॉर्टेंट बात तो ये है, देखिए, अगर हसनपुर में या हरदोई में या गोरखपुर में or in Trivandrum, when a person is making a vote in the elections, they are not making a vote only for the person whom they are voting for. They are also voting for a person because of the association of that candidate with a particular political party. And imagine if I vote for a particular candidate in the elections and after election he switches political parties, is that not a betrayal of my vote as an electorate? Is that not something which should not be acceptable in a democracy? And that's the reason why we are talking about defection. The reason therefore why defections are a big problem as far as the politics is concerned is because they are often done due to lure of money or due to lure of power or due to a number of other reasons. For example, if I was to talk about the anti-defection law that was enacted by the Parliament of India in the year 1985, its statement of objects and reasons stated the following. तो किसी भी लॉ को जब पास किया जाता है तो उसके साथ में एक स्टेटमेंट ऑफ रीजंस एंड ऑब्जेक्ट्स अकंपनी किया जाता है. And the statement of reasons and objects of this particular law was: the evil of political defections has been a matter of national concern. If it is not combated, it is likely to undermine the very foundation of our democracy and the principles which sustain it. So therefore, it's very important for us to understand why the anti-defection law was brought in India. So as the name suggests, the anti-defection law was aimed at curbing defections in India. (1967) to 1980s was an extremely turbulent time in Indian politics. Some of the statistics suggest that during this particular period, there were as many as 4,000 defections that took place in Indian politics. Not only that, this was a phase of instability where round about 45 governments in India fell because of the defections that happened of the MLAs or the MPs from one political party to the other. Therefore, the main objective of bringing the anti-defection law in India was as follows. First and foremost, the anti-defection law was introduced in order to ensure government stability. There were many instances, as I just stated, where MLAs had defected from the ruling party to the opposition and had led to the downfall of the government. We wanted to curb this kind of a practice because it was making Indian politics extremely unstable in nature. The other reason because of which we wanted to bring in the anti-defection law was to curb the role of money power. In politics. That was to curb the role of money power in politics. The idea was that there are many cases where individuals have been paid huge money by the opposition parties for defection. And if this continues, then the free and fair elections or free and fair politics in India would become a distant dream. And the third reason because of which we wanted to bring in an anti-defection law in India was to preserve the electoral mandate. If a voter has voted for a particular individual in the elections, as I said earlier as well, it is not only because of that person, but also because of the political allegiance of that person. And if later that person goes on to change the political party, of course it is a betrayal of the political mandate that has been provided by the electorate in the country. Now, let's quickly discuss, once we have understood why the anti-defection law was introduced in India, a certain background of the way the anti-defection law had been enacted in India. So this law was passed in 1985 by the Parliament of India in form of the 52nd Constitutional Amendment Act. As a result of this Constitutional Amendment Act, two important provisions were added into the Indian Constitution. First and foremost, Article 102 and Article 191 were added with two new clauses. One was Article 102 Clause 2 and the other one was Article 191 Clause 2. Secondly, we also added Schedule 10 in the Indian Constitution. Now, what are the provisions of 102, 191 and Schedule 10 of the Indian Constitution? simply stating Article 102 clause 2 and 191 clause 2 state that a person who is a member of the parliament or the state legislature would be subject to disqualification with respect to the provisions under Schedule 10, which is nothing but where the anti-defection law provisions have been mentioned in the Indian Constitution. And that's what we will be discussing in detail right now. Actually, the origin of the Anti-Defection law or the 52nd Constitutional Amendment Act in India can be traced back to 1969. A committee was formed under the chairmanship of Y.B. Chavan by the Government of India, and this committee had provided recommendations on how hundreds of legislators in India have been defecting from one political party to the other, causing turbulence in Indian politics, instability in Indian politics, and in order to curb that, we need to bring in a legislation. There were various attempts that were made in 1973 and 1978 towards this particular cause, but unfortunately we were not able to make any headway. But in 1985, when the Rajiv Gandhi government was able to come into power with an astounding majority, the original Ab Ki Baar 400 Par, they were able to bring an enormous mandate with them, and they were also able to ensure that this 52nd Constitutional Amendment Act was passed by the Parliament of India. Now, before we get into what are the issues with the functioning of the anti-defection law in the country, let's quickly discuss how this law actually works in India. What are some of the important provisions of the anti-defection law in the country? So let's get into the thick of the polity concepts here when we talk about the anti-defection law in India. First and foremost, what this law says is that if a person who has been chosen as a member of a house, a state legislature or the parliament, voluntarily gives up the membership of their political party, they shall be subject to the provisions of the anti-defection law, and they are liable for disqualification from their membership of the house. So what that means is, let us say that if I join the house as a member of parliament from party X on party X ticket, and after winning the elections I switch to party Y, then I would be liable for disqualification under the anti-defection law, and I can no longer continue as a member of the parliament. If I want to become a member of parliament again, I need to recontest the elections. The second aspect of the anti-defection law is that if a member of a house votes contrary to or abstains from voting contrary to their party directions, and if their actions are not approved by the political party within a period of 15 days, or if they have not taken prior permission from their political party, they shall be liable for disqualification. तो सपोज कीजिए किसी एक पर्टिकुलर बिल के ऊपर आपकी पॉलिटिकल पार्टी ने आपको बोला दैट यू शुड बी वोटिंग इन फेवर ऑफ दैट बिल, बट यू एंड अप voting against that bill, or your party asked you to be present in the house to vote in favor of that bill. You were present but you abstained from voting in favor of that bill, or you did not vote against that bill and you neither voted in favor of that bill. Then in that particular case there are two options which are available to you. या तो आपने अपनी पॉलिटिकल पार्टी से पहले से ही परमिशन ली होती इस पर्टिकुलर मैटर के ऊपर, और योर पॉलिटिकल पार्टी gives you permission or condones your actions within 15 days. If none of those things happen, then you are liable for disqualification under the anti-defection law. The third is, if you are an independent member of the house. So you have been chosen as an independent member of the house, not on the ticket of any particular political party, but you decide to join a particular political party after getting elected to the house, you shall be again liable for disqualification under the anti-defection law. बिकॉज लोगों ने आपको शायद वोट इसलिए भी किया होगा बिकॉज आप एक इंडिपेंडेंट मेंबर हैं, और अब आप अगर एक पॉलिटिकल पार्टी को जाके ज्वाइन कर लेंगे, सो यू शुड डेफिनेटली बी सब्जेक्ट टू डिस्क्वालिफिकेशन. द फोर्थ इज, इफ यू आर अ नॉमिनेटेड मेंबर ऑफ द हाउस, let's say you are a nominated member of the Rajya Sabha or that of the Legislative Council, the provision in the law states that you have a period of 6 months to decide if you want to join a particular political party. But if such a person joins a political party after 6 months of election, then they should be subject to disqualification under the anti-defection law. So these are some of the reasons on the basis of which a person can be subject to disqualification under the anti-defection law in India. If you voluntarily give up the membership of your political party, if you vote contrary to the directions that have been provided by your political party, or you abstain from voting, and if of course you have not got the prior or the later approval, if you are an independent member and joined a political party, and if you are a nominated member and if you joined a political party after 6 months of your election to the house. Now, one interesting thing to note here is that voluntarily giving up membership of a political party is not the same as resignation. What the court has stated is, let us say that if I have resigned from my political party, then of course in that case I shall be liable for disqualification on the grounds of anti-defection law. But let us say I am a member of a particular political party, I don't join another political party, but for all practical purposes I have become member of some other political party. तन मन धन से मैं किसी और political party का member बन चुका हूं, but मैंने ये formally नहीं किया है because मुझे पता है कि मेरे ऊपर anti-defection law लग जाएगा. In that particular case and circumstance, the court has stated that your behavior within and outside the legislature would also decide whether you have actually defected or not. So there was a case that came up in UP that there was a person who was a part of a particular political party and he did not want to be disqualified from the membership of the house but wanted to join another political party. तो उन्होंने दूसरी पार्टी की सारी मीटिंग्स अटेंड करनी शुरू कर दी, उनके दूसरी ऑपोजिशन पार्टी के बारे में तारीफें करनी स्टार्ट कर दी इन द लेजिस्लेचर, एंड नॉट ओनली दैट बट outside the house also they would often be seen attending the meetings and conferences of that particular political party and praising the political leadership of that particular political party. Now the members of his original political party filed a case and stated that, sir, this person has actually changed his political party, but simply because he has not resigned from the political party officially does not mean that anti-defection law should not apply on him. In this particular case, which is also known as Ravi Nayak versus Union of India, the Supreme Court of India in its judgment of 1994 stated that the conduct of a person is also important in judging whether the defection has happened or not. So whether a person has actually defected or not would depend upon the conduct of an individual as well. Now, let me tell you a few other things with respect to the anti-defection law provisions in India. In the anti-defection law, there is an exception as well. The exception is if 2/3 members of a political party form a new group out of that political party and go and join some other political party. In such a scenario, the anti-defection law shall not apply. So let's say that if a particular political party has 30 MLAs and if 20 of these MLAs of this political party leave the political party and they go and join some other political party, then in that particular case it would be called as a situation of merger, and those members of that political party would not be subject to any kind of disqualification under the anti-defection law. Actually, originally in the law, this provision was that if 1/3 members of a political party in the house split from the party and they form a new party, the provisions of anti-defection law shall not apply on them. But what this started to promote was that even though the original law was aimed at bringing in or prohibiting individual defections, इस लॉ की वजह से, इस प्रोविजन की वजह से जो ओरिजिनल लॉ में था, उससे होने क्या लगा, that it started to promote defection of large number of members of a political party. So let us say if I am a person who belongs to an opposition party and I want to create a rift in a particular political party, मैं एक आदमी को तो नहीं खरीद सकता हूं because एंटी डिफेक्शन लॉ लग जाएगा, पर अगर मैं 10 लोगों को खरीदने के पैसे रखता हूं, then I can break that party apart. So this had started to promote a lot of fragmentation. ये जो split का exception था, that had started to promote a lot of fragmentation in Indian politics. And as a result of that, the parliament decided to make a change in this provision. So therefore, this provision of split was changed into provision of merger via the 91st Constitutional Amendment Act of 2003. Now the provision that we have in the law in India is the exception of merger. If 2/3 of the members of a particular political party split from a political party and join some another political party, then in that case the provisions of the anti-defection law would not apply. But there is one important information that you need to have. What exactly is a merger is still a big question mark. There are two ways in which this merger is interpreted by people. कुछ लोगों का कहना है that for the merger to happen, in the first scenario, first political party as a whole must accept merger, and then 2/3 of the members of the political party must provide approval, and that's when the merger would happen. Some people say that no, that's not correct. The right interpretation would be when 2/3 of members in the house provide approval, and that should be enough to ensure the merger of a particular political party with the other political party. Now this is a legal debate and which is going to have significant implications on how the anti-defection law is going to operate in India, and this question is still lying before the Supreme Court of India and it is open-ended as of now. So we will not really comment on it, but we will have to watch, we will have to wait what the Supreme Court says on this particular issue. Now, the decision under the anti-defection law on whether a person actually should be disqualified on these grounds from the membership of the House is a decision that is supposed to be taken by the Speaker or the presiding officer of that particular House. So the ultimate decision maker, according to the paragraph 6 of this particular law in Schedule 10, is supposed to be made by the presiding officer of Lok Sabha or Rajya Sabha. So presiding officer of Lok Sabha or Rajya Sabha or the Speaker of Legislative Assembly or the chairperson of the Legislative Council is the one who's supposed to be deciding over the decision of disqualification under the anti-defection law. The paragraph 6 of Schedule 10 of the Indian Constitution is an important provision in this regard. पार्लियामेंट के अंदर इस पे काफी डिबेट हुई कि ये डिसीजन मेकिंग पावर जो है वो डिस्क्वालिफिकेशन की स्पीकर को क्यों दी जाए, और इस पे कुछ मेंबर्स का ये कहना था दैट इफ वी गिव दिस पावर ऑफ डिस्क्वालिफिकेशन अंडर द एंटी डिफेक्शन लॉ टू द कोर्ट्स इन इंडिया, then there would be a possibility that this issue would go into endless litigation and there would never be a decision which would be taken on the disqualification of the members, and therefore the decision of disqualification should be instant and it should lie with the presiding officer. Originally the constitution also mentioned that whatever is the decision of the presiding officer with respect to anti-defection law shall be final and not subject to judicial review. It should be final and it should not be subject to judicial review of any kind. Now see, in a country like India, unfortunately this provision has not worked out really well. The reason for that primarily has been that there have been question marks over neutrality of the speaker's post in India. In many other democratic countries of the world, a provision that is followed or a convention that is followed is that once a speaker is elected to the house from a particular political party, they are supposed to make a resignation from that particular political party after getting elected as the speaker. For example, in UK, a principle that is followed by their parliament is called as once a speaker, always a speaker. What this provision means is as follows. If a person is elected to the Speaker of the House of Commons in Britain, they resign from their political party. But the problem is that if they resign from their political party, the next elections they would have to fight as an independent candidate. So therefore, in Britain what is done is that as a mark of respect and to ensure the neutrality of the office of the Speaker, the person who is elected as the Speaker is elected uncontested from his constituency in the next election also, and that person continues to be the Speaker of the House and act as a neutral speaker. Even in the third elections, it may be possible that that same person would be elected as the speaker again, and that person would continue to be elected unopposed from his constituency. Of course, some of you may say that isn't that compromising the wishes of the people of that particular constituency? Yes, but then you have to look at which is the larger evil that we want to solve. Don't we want a neutral speaker in the parliament? Isn't that something which is more preferable for us as compared to the voice of a particular constituency in the country? So it's not that the person who has been chosen as a speaker is going to remain a speaker for their end of their life until the time they die. It's only for 2 or 3 terms that this kind of a situation continues, and after that they retire from active politics and a new person comes into the picture. This is the situation that is followed in UK, which ensures the neutrality of the office of the speaker. But in India, unfortunately, there have been so many times where the speakers, those who are elected to the house, are not necessarily neutral in their approach, or at least they do not seem to be neutral from the perspective of the opposition members. There have been numerous instances where some of the speakers in the past have even gone on to make statements or attend the meetings of their political party, thereby raising doubts over their neutrality. And this is one big challenge which is associated with the way the anti-defection law works in India, because ultimately a lot of times it has been misused by the speakers. How? We will be discussing that. Now, let me quickly tell you that the Constitution does not prescribe any time limit. In which the presiding officer or the speaker is supposed to take a decision over disqualification. And since there is no time limit that has been prescribed, there have been several instances where an individual has defected from one political party to the other, and despite that, decision was not taken by the speaker over their disqualification. In some cases, some of these people went on to become ministers in the government as well, and still no decision was taken by the speaker. This is primarily the biggest concern as far as the lack of neutrality of the office of the speaker is concerned. In a case of 2020, which was known as the Kesham Meghachandra Singh case, the Supreme Court of India had stated that the speaker, who had been sitting over an anti-defection petition for over 3 years, had misused the law. And the Supreme Court in this case stated that ordinarily any of the decisions with respect to anti-defection law shall be taken by the presiding officer within a period of 3 months. Except in exceptional circumstances, this decision should be taken as soon as possible within a period of 3 months. And the Supreme Court did something even more significant in this particular case. They actually urged the Parliament of India for amending the constitution to take away the powers of deciding the disqualification of a member under the anti-defection law from the speaker, given the question marks over his or her neutrality, and vesting this with an independent tribunal that should be headed by a retired judge of Supreme Court or the High Court. So in this case, the Supreme Court had set a indicative time limit of 3 months with respect to the anti-defection law. The second thing which the Supreme Court did in this particular case was that they stated an independent tribunal should be set up, and this independent tribunal would be headed by, chaired by a retired judge of Supreme Court or High Court in order to ensure neutrality in the proceedings related to the anti-defection law. There is one more important case which I want to tell you about, and that is the Kyoto Holohan case. This was a judgment that was provided by a constitutional bench of the Supreme Court of India in the case known as Kyoto Holohan versus Zachelu, and in this case the Supreme Court of India stated that the provisions of the anti-defection law, which state that the decision of the speaker shall be final in anti-defection cases, is unconstitutional and goes against basic structure of the Indian Constitution. The reason for that is because this provision takes away powers of judicial review from the courts, which is a part of the basic structure of the Constitution. Decision that is taken by a speaker in any such case, that speaker is acting as a tribunal, and therefore it would be subject to scrutiny of the courts in the country. Another important case which was decided by the Supreme Court was in the year 2020, and this was Nebam Rabia versus Deputy Speaker. Now, in Nebam Rabia versus Deputy Speaker, this was a case from Arunachal Pradesh. The Supreme Court had stated that in case disqualification of there is a notice that has been introduced in the Parliament or in the House for the removal of the Speaker of the House, the Speaker himself or herself cannot proceed to decide the disqualification petitions. The idea was that अगर आपकी खुद की disqualification जो है वो under question, आपकी खुद की membership अगर question mark में है और अगर आपके removal के लिए एक notice introduce किया गया है, तो आप दूसरे की disqualification decide नहीं कर सकते हैं. But I have a problem with this particular provision. It has often been misused by the political parties in power. What they tend to do is that they tend to instigate some of the other opposition party to introduce a provision, introduce a notice for the removal of the speaker in the house, and क्योंकि जब तक ये स्पीकर का रिमूवल का नोटिस हाउस के अंदर रहेगा तब तक वो डिसीजन नहीं ले सकता है एंटी डिफेक्शन लॉ के ऊपर, और बहुत सारे ऑपोजिशन के एमएलएस को रूलिंग पार्टी जो है अपनी साइड खींच के ले आती है. सो दिस इज ऑल्सो वन ऑफ द ट्रबल्स दैट वी नीड टू कीप इन माइंड एज फार एज the judgment of the court is concerned. Recently as well, in 2025 there was a judgment that was provided by the Supreme Court, and in that case the Supreme Court had stated that the speaker does not enjoy any kind of constitutional immunity under article 122 or 212 of the Indian Constitution, which applies with respect to freedom of speech within the parliament, because they are acting like a tribunal under 10th schedule of the constitution. और इस केस में भी सुप्रीम कोर्ट ने यही सजेस्ट किया that there should be at least a 3 months guideline that should be put on the speaker for deciding over the anti-defection cases. But there are a number of questions that remain unanswered as far as the anti-defection law in India is concerned even till date. Criticisms के बारे में मैं अभी बहुत ही जल्दी बात करूंगा, but what are some of those questions that remain unanswered as far as the anti-defection law in India is concerned? पहला सवाल तो ये आता है that who is the real political party? अगर दो पॉलिटिकल पार्टी के फैक्शंस हैं जो क्लेम कर रहे हैं कि हम रियल पॉलिटिकल पार्टी है, और किसको एक्चुअली रियल पॉलिटिकल पार्टी माना जाएगा, समथिंग दैट वी हैव सीन इन केस ऑफ शिवसेना recently, that is a question that remain unanswered till date. The second question is that the decision over anti-defection is supposed to be decided by the speaker, but which political party is going to get which symbol is decided by the Election Commission of India. तो सवाल ये आता है कि सपोज कीजिएगा कि अगर इलेक्शन कमीशन दो पॉलिटिकल पार्टीज का जो एक फैक्शन है, एक पॉलिटिकल पार्टी के जो दो फैक्शंस हैं उसमें से एक को अगर वो सिंबल दे देता है और स्पीकर दूसरे को सिंबल दे देता है, तो किसकी बात मानी जाएगी? दिस इज ऑल्सो अ क्वेश्चन दैट रिमेन्स लार्जली अनआंसर्ड एज ऑफ नाउ. But now let me quickly talk about some of the criticisms of the anti-defection law as well. See, the anti-defection law in India was enacted with the purpose of ensuring stability, reducing the money power in the elections in India and the electoral politics in India. But unfortunately, there are a large number of criticisms of this law. First and foremost is that it has compromised the independence of individual legislators in India. The second issue which is there with respect to this law, तो basically इसका कहने का मतलब ये है that an individual legislator does not really have much of an opinion or a choice. They have to act according to the directions that have been provided by their political party, as if they are a puppet in the hands of their political party. Even if my constituency wants me to vote against a particular bill, I will have to vote in favor of that particular bill if my political party wants me to do that. Isn't this weakening representative democracy in the country? Doesn't it weaken the idea of a member of the parliament being a representative of the people other than any other thing? The second thing that we can also mention is that it has also weakened the role of parliament as a deliberative body. If all the people in the parliament are going to be singing the tunes of their political party, then what kind of quality of debates can we expect in the Parliament of India? There have been several situations in which people have not really been wanting to comment individually on bills, and even the functioning of the committees of the parliament has been affected severely as a result of the same. So overall culture of the political debates in India in the parliament has been affected as a result of the anti-defection law. The third issue that we have with the law is lack of time limit with respect to the decision that is supposed to be taken by the presiding officer over the anti-defection law, and that often leads to several cases in which individuals have defected to the other political parties and no decision has been taken at all with respect to their disqualification. The fourth issue is the ambiguity with respect to merger, something that I have discussed with you earlier also just a while back. The fifth issue that we can highlight is the definition of the term voluntarily gives up membership. जब हम ये कह रहे हैं कि हम एक इंसान के कंडक्ट से ये इन्फ्लुएंस निकालेंगे कि whether he has joined some other political party or not, but let us assume that I am friends with the member of the opposition of another political party, and I often end up being seen in public places, or I have often seen sharing a dais with him on stage, does that mean that I have shifted my political party? So the ambiguity that exists regarding voluntarily giving up membership is also a big challenge which we can talk about. And the last thing that we can also see is that there is always a work around the anti-defection law, and that workaround is that even if you are subject to the anti-defection law, you can simply resign from the political party, or you can resign from your seat and then you can recontest the elections from the other political party and get elected to the house. Now the question that therefore arises is that this person, by doing so, is simply raising the cost for the taxpayer by forcing the taxpayer to go into a by-election and to vote again. So should something like that be allowed? So the problem with the fact that people can always find resignation as a workaround the anti-defection law is also something which is worrisome and is supposed to be taken into consideration. Now, having said that, there are a number of proposals which have been made by expert committees as far as the anti-defection law in India is concerned. What are some of these proposals that have been made by the expert committees? Let's note down those as well. First and foremost, there was a committee that was formed by the government in the early 90s, and that was called as the Dinesh Goswami Committee on Electoral Reform. Now, the Dinesh Goswami Committee, in its recommendations with respect to the anti-defection law, had suggested that the decision over disqualification should not be taken by the speaker, but should be taken by the governor or the president on the advice of the Election Commission of India. So the governor or the president of India on the advice of the Election Commission of India, which is considered to be an independent constitutional body, is the process that should be followed in the country. The Law Commission of India in its 170th report had stated the same. So the same recommendation had been stated by the Law Commission of India in its 170th report as well. Secondly, we can also talk about the Election Commission's recommendation, where they have stated that the decision on this particular matter should be taken by the Election Commission itself and by no other body, because it relates to the process of the elections in the country. The fourth is the Second Administrative Reforms Commission has suggested that the decision should be taken by the President or the Governor on the advice of the Election Commission of India. So the same recommendation again, where the decision should be taken by the Election Commission of India. One thread that you can therefore see commonly amongst all these recommendations that have been provided is that the institution of the speaker is not being trusted by anyone, and ideally therefore we definitely need to take away this decision making power from the hands of the speaker if we want the anti-defection law to work effectively in the country. Another important recommendation that has been provided by the Dinesh Goswami Committee is that the whip or the direction of the political party to vote in the house. So this is a recommendation that has been provided by Dinesh Goswami Committee. The direction of the political party to vote in the house should apply only in confidence and no confidence vote. Because if the original intention of the law was to preserve the stability of the government, then to ask the legislators to vote on all the matters according to the directions that have been issued by their political party is something which cannot be acceptable. We also need to be following the recommendations of the Supreme Court that there should be a 3 months timeline that should be imposed with respect to the decision over the anti-defection law. And then the last thing that we can also mention is that if there is a person who has been disqualified on the grounds of the anti-defection law, then they should not be allowed to contest the next cycle of elections. This is also one of the recommendations that has been made by several individuals. Now, see, the anti-defection law in India has therefore been in controversy for the longest period of time, and it definitely needs reforms, is something that we all can agree upon. In fact, if I was to talk about Gaya Lalji's son Udayban has actually spent decades defending his father by stating that कि नाम तो केवल मेरे पिताजी का ही खराब किया गया आया राम और गया राम पॉलिटिक्स बनाकर, बट उनसे भी ज्यादा वर्स बहुत सारे लोगों ने मल्टीपल पॉलिटिकल पार्टीज चेंज करी थी, बट माय फादर हैज बीन मेड द स्केपगोट ऑफ. एंड आई truly agree with that as well to a large extent, because Gaya Lal ji was just a symptom of the entire problem that plagues Indian politics, which is the role of money and muscle power, the way the elections are twisted in India, the way the MLAs and the MPs are taken to the resorts and they are locked behind those resorts so that they cannot be defecting to the opposition parties. ये आया राम और गया राम की पॉलिटिक्स इंडिया के अंदर इसलिए सस्टेन करी है बिकॉज वी एज वोटर्स ऑल्सो हैव नॉट बीन अवेयर एज फार एज वोटिंग टुवर्ड्स दीज पीपल दोज हु आर डिफेक्टर्स इन द पॉलिटिक्स इज कंसर्न्ड. And unfortunately, the anti-defection law that was brought in to stop defection in India has actually legitimized defection in the country, where once you bought one man, now you can organize 2/3 or you can engineer mass resignations from the other political party and get the entire party to be defected towards you. Therefore, if we have to truly solve this problem going ahead in the future in India, we need to be finding more robust solutions to this. Gaya Lal ji must have changed 3 political parties in a day, and we tried to make a constitutional provision to stop people like him from doing so. But 41 years later, we are still asking the same question. How can we stop more Gaya Lals in Indian politics? Unfortunately, we have still not been able to find a comprehensive solution to this particular problem, and possibly more discussion, deliberation and debates in the parliament in India in future would help us in resolving this issue. There was one question that has been asked by UPSC in 2013 mains examination with respect to how the anti-defection law has compromised the role of an individual MP in India and what are the other factors that have contributed to the same. You can also look at some of the other probable questions that may be asked by UPSC related to this particular topic, especially where the question may try to bring in that how the anti-defection law has failed in India and has only raised the price of defection in the country, what are the criticisms of the provisions of the anti-defection law and what needs to be done in order to make it more effective in nature. I hope you enjoyed this particular session of Manthan 2026. This was the 5th session from my end. I know that there was a particular delay in uploading of this session because of the technical glitches at my end, but I will try to be more regular and more disciplined as far as the uploading of these sessions in the coming days is concerned. Till then, thank you so much again for all the encouragement and support that you have been providing on the channel. Please keep providing your comments and feedback. I would be more than happy to respond to them on an individual basis. You already know my email ID, which is jatinguptacsc@gmail.com, and my Telegram channel, which is Jatin Polity. Till next time, I meet you for the 6th session of Manthan. All the very best, and I will see you very soon. Take care. Bye bye. All the best.